Paragraph 4 of the affidavit may kindly be seen. Page 288. They say that it is in support of the plaint.
No, and for effective adjudication of the suit.
Document in the
My lords, they have filed a suit for damages. This is a license agreement. Now, my lords, they are trying to produce all the documents in support of their claim, which they had in possession of.
No, this works on a different footing. Even if they had in their possession, they will have to file it under 11.5. No doubt about it. All the documents should be along with the plaint. Law does not accept fragmented production of documents. Fine. Now, against the written statement, their defense in the written statement, law permits production.
They have not stated in the affidavit.
They have not stated, but
they have not stated in the affidavit.
The purport of it should be that only.
No, my learned friend is right. My learned friend is right in that the affidavit doesn't state it.
If they had stated that, you had no case. Huh?
Like
Now he will state that. We will record that it is only for this purpose.
Please.
You want to search something? You want to search something, we'll grant you time. No problem.
In fact, before the learned trial judge had expressed that this is an application that can be disposed of by subjecting us to costs. We agreed to that. They said, no, we want to argue it. And of course, the learned trial judge focuses on the fact that the application is preferred at the time of recording evidence. That seems to be the heart of the order.
Issues a frame agreement.
Issues can be framed the next day.
Not on the stage of the suit, sir. Not on the stage of.
If it were to be after framing of issues, I also would have dismissed it, definitely. It's not that. No, you want to search something and make that.
Kindly I call it after a week.
I'll call it on Thursday.
Please.
Next Thursday.
Yes.
Let's next Thursday in preliminary hearing. We'll dispose it of. Yes. Ashte, the purport is that I will record it is only in furtherance of that and nothing else. And his claim on those documents also will be only in furtherance of countering the points in the written statement filed by you. He will not use it for anything else.
Dismissal 137.
Non-compliance.
Complaints ಮಾಡಿದೀನಿ.
ಮಾಡಿದೀರಾ?
ಮಾಡಿದೀನಿ. ಅದರಲ್ಲಿ 2 ಕಂಪ್ಲೇಂಟ್ಸ್ ಅಲ್ಲಿ ಒಂದು
ಸ್ಮಾಲ್ ಇದ್ರು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ.
ಇಲ್ಲ ನಾನು ಕ್ಲಾರಿಫೈ ಕೊಟ್ಬಿಡ್ತೀನಿ.
ಕ್ಲಾರಿಫಿಕೇಶನ್
ಅಲ್ಲಿ ಸ್ಕ್ರೂಟಿನಿ ಹೇಳಿದೀನಿ ಬಟ್ ಅವರು ಕ್ಲಾರಿಫೈ ಆಗ್ತಾ ಇಲ್ಲ. ಹಾಗಾಗಿ
ಸ್ಕ್ರೂಟಿನಿ ಕ್ಲಾರಿಫೈ ಆಗ್ತಾ ಇಲ್ಲ, ಅದಕ್ಕೆ
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸಬ್ಮಿಟ್ ಮಾಡಿ ಅಂತ ಅವರು
ಕೊಡಿ. ವಕಾಲತ
ವಕಾಲತಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಬಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ 1 ಮತ್ತು ಪಿಟಿಷನ್ ನಂಬರ್ 2 ಇಬ್ರು ಸೇಮ್ ಇದಾರೆ.
ಸೇಮ್ ಇದಾರಾ?
ಸೇಮ್ ಇಬ್ರು ಒಬ್ಬರೇ ನೇಮ್ ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಏನಂದ್ರೆ ಲೋಯರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇವರು ಇಬ್ಬರು ಪಾರ್ಟಿ ಮಾಡಿದ್ರು.
ಸೇಮ್ ಇದಾರೆ.
ಅನೆಕ್ಷರ್ ಡಿ 54
ಸೇಮ್ ಇದಾರೆ ಅಂದ್ರೆ ಟ್ವಿನ್ಸ್ ಮತ್ತೆ
ಪರ್ಸನ್ ಸೇಮ್ ನೇಮ್ ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಅನೆಕ್ಷರ್ ಡಿ ನೋಡಬಹುದು ಸರ್. ಪೇಜ್ ನಂಬರ್ 54. name changes ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
Your Lordship, the interim orders were revoked 2 hearings ago, my lords.
Revoked already?
Yes, my lords.
Office objections.
2001
pending office objections overruled. Yes.
Next date ಅಲ್ಲಿ ಒಂದು office objection complex ಮಾಡ್ತಾರೆ.
Overruled ಅಂದ್ಮೇಲೆ comply ಯಾಕೆ ಮಾಡ್ತೀರಾ ಸರ್? Yes.
Your Lordships, that is the bone of contention here, my lords. Petitioners 1 and 2 claim to be different, but they claim to be that is their case, my lords. Our cases, they are 2 different persons, and one gets the GPA, the other petitioner number 2 executes the sale deed, my lords. That's the entire case that we have before the lower court, my lords.
Both are same. 2001 ನಲ್ಲಿ
Your Lordships, 95 nalli petitioner number 1 obtains the GPA, my lords, from the plaintiff's husband.
Where is the
page number 55?
Petitioner number 1 N Gangadhar?
Yes, yes.
Who is he?
He claims to have received a GPA from the plaintiff's late husband, my lords. And petitioner number 2, acting on the same GPA, he executes sale deeds in favor of petitioner 3. Petitioner 3 once again executes sale agreements in favor of petitioner number 2, my lords. And my lords, all these transactions, they bifurcate the property into 2 halves, executed amongst themselves on the same day, my lords. The issue here is easinala reflect agala, my lords, if those kind of transactions were conducted. Hence, we got to know recently when the plaintiff attempted to sell the property, these particular transactions came to light, and she has filed a suit seeking declaration of all the documents, my lords, stating that these particular sale deeds are null and void and not binding on me. And that is the entire suit here, my lords. And our contention is petitioner 1 and 2 are two
Where are you
different.
here?
Page number 55.
What is challenge here?
Your lordships, they file order 7
Oh,
rule
Order
11.
7 rule 11.
Yes,
Your
my
Honor.
lords.
Yes.
35 years ಆದ್ಮೇಲೆ ಈಗ ಬಂದು ಕ್ಲೈಮ್ ಮಾಡ್ತಾರೆ ಪ್ರಾಪರ್ಟಿ ನಂದು ಅಂತ.
35 ವರ್ಷ ಆಗಿದೆ.
ಹೌದೌದು.
My lords.
ಅವಾಗ್ಲಿಂದ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ನಾವೇ ಇದೀವಿ, ಟ್ಯಾಕ್ಸ್ ಕಟ್ಕೊಂಡು ಬರ್ತಾ ಇದೀವಿ. ಅಲ್ಲಿ
That's
ತನಕ
the-
ಯಾವ್ದು
no,
ಡಿಫರೆನ್ಸ್ ಇಲ್ಲ. ಏನ್
that
ಮಾಡ್ತಾ
is-
ಇದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ,
I approach.
ಈಗ ಒಂದ್ ಕೇಸ್ ಆಗ್ತದೆ, ಆ ಕೇಸ್ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ, ಮತ್ತೆ ಇನ್ನೊಬ್ಬ ಉಟ್ಕೋತಾನೆ ಈ ಪ್ರಾಪರ್ಟಿ ನಂದು ಅಂತ. ಆ ಪ್ರಾಪರ್ಟಿನ ಎಂಜಾಯ್ಮೆಂಟ್ ಮಾಡಕ್ಕೆ ಬಿಡ್ತಾ ಇಲ್ಲ.
ಅಯ್ಯೋ, ಒಂದ್ ನಿಮಿಷ ತಾಳಿ. ಎಸ್, ಎಲ್ಲಿದೆ, ಯಾವಾಗ ತಗೊಂಡಿದ್ ನೀವು?
2005
2005. 35 ವರ್ಷ ಹೆಂಗಾಯ್ತು?
ಸೇಲ್ ಡೀಡ್ 2005 ಅಲ್ಲಿ GPA ಕೊಟ್ಟಿದ್ದು ನಮ್ಗೆ
ಹಾ.
ಅಲ್ಲಿ
86 ಅಲ್ಲಿ. ಸೇಲ್ ಡೀಡ್ ಯಾಕಾಯ್ತು 2005 ಅಲ್ಲಿ?
ನನಗೆ GPA ಕೊಟ್ಟಿದ್ರು.
ನಿಮ್ಗೆ ಅಂದ್ರೆ ನೀವು ಯಾವ ಪೆಟಿಷನರ್?
ಪೆಟಿಷನರ್ ನಂಬರ್ 1
1
GPA ಕೊಟ್ಟಿದ್ರು.
ಆಲ್ ರೈಟ್.
ಬಟ್ ಅವ್ರು ವಿತ್ ಸೇಲ್ ತಗೊಂಡಿದ್ರು, GPA ವಿತ್ ಸೇಲ್ ತಗೊಂಡಿದ್ರು.
ಆಯ್ತು.
ಹಾಗಾಗಿ 2005 ಅಲ್ಲಿ ಸೇಲ್ ಮಾಡ್ತಾರೆ
ನಿಮಗೆ.
ಹೌದು.
ಎಲ್ಲರೂ ನೀವೇನೆ? ಯಾರಿಗೆ?
ಪಿಟಿಷನ್ ನಂಬರ್ 3 ಗೆ
ಪೆಟಿಷನ್ ನಂಬರ್ 1, ಪೆಟಿಷನ್ ನಂಬರ್ 3 ಗೆ 2005 ಅಲ್ಲಿ ಸೇಲ್
ಮಾಡ್ತಾರೆ.
ಪೆಟಿಷನ್ ನಂಬರ್ 2 ಏನ್ ಮಾಡಿದ್ರು? 3 ಗೆ ಮಾಡಿದ್ರು. ಆಮೇಲೆ
ಬೋತ್ ಆರ್ ಸೇಮ್, 1 and 2 ಆರ್ ಸೇಮ್. 2001 ಅಲ್ಲೇ ನಾವು ನೇಮ್ ಡಿಕ್ಲರೇಷನ್ ಮಾಡ್ಕೊಂಡು ನೇಮ್ ಚೇಂಜಸ್ ಮಾಡ್ಕೊಂಡಿದ್ವಿ.
ನೇಮ್ ಚೇಂಜ್ ಮಾಡಿದ್ರಾ?
From ಪೇಜ್ ನಂಬರ್ 55.
ವಾಟ್ ಟು ವಾಟ್?
ಗಂಗಾಧರ್ ಟು ಸೂರ್ಯಪ್ರಕಾಶ್.
ಗಂಗಾಧರಿಂದ ಸೂರ್ಯಪ್ರಕಾಶ್. ತುಂಬಾ ಚೇಂಜ್ ಆಗೋಯ್ತಲ್ಲ.
2001 ಅಲ್ಲೇ ಮಾಡಿದ್ವಿ.
ನೇಮ್ ಚೇಂಜ್ ಹೆಂಗ್ ಮಾಡಿದ್ರಿ?
ಡಿಕ್ಲರೇಷನ್
ಸೂಟ್ ಹಾಕಿದ್ರಾ?
ಇಲ್ಲ, ಡಿಕ್ಲರೇಷನ್ ಅಫಿಡವಿಟ್ ಮತ್ತೆ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ವಿ.
ಇನ್ಮೇಲೆ ನೀವು ಇದು ಅಂತ.
ಅದಾದ ನಂತರದಲ್ಲಿ 2015 ಅಲ್ಲಿ ಸೂಟ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ ಇದೇ ಪ್ರಾಪರ್ಟಿ ಮೇಲೆ. ಆ ಪ್ರಾಪರ್ಟಿ ನಮ್ದು ನೇಮ್ ಚೇಂಜ್ ಆಗಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ. ಅದ್ರಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ ಆಗಿ ಮಾರ್ಕ್ ಆಗೋಗಿದೆ ಸರ್.
ಅದೇನಾಯ್ತು? ಸೂಟ್
ಡಿಸ್ಮಿಸ್ ಆಯ್ತು.
ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಸೊ ನಿಮ್ ನೇಮ್ ಕನ್ಫರ್ಮ್ ಆಗೋಯ್ತು, ಸೂರ್ಯಪ್ರಕಾಶ್.
Your lordships, the affidavit that they produce, the date is 7/7/2001, and in 2004 the same petitioner number 1 executes a sale agreement which is all marked, my lords, in favor of petitioner 3. 2005 nalli petitioner 2 executes sale deed in favor of petitioner 3. 2006 petitioner 3 executes a sale agreement in favor of petitioner 2. My lords, all the transactions scheduled property na bifurcate ಮಾಡ್ತಾರೆ into 2. Same day they execute 2 sale deeds just to circumvent the EC, my lords. Illare encumbrance certificate na
ಪೊಸಿಷನ್ ಯಾರಿದ್ದಾರೆ?
my lords, nobody is there in possession.
Nobody is there.
My lords, it's an
We are
empty
in
plot of
possession.
land, my lords.
Vacant land.
And it's observed in the judgment as well.
ನೀವ್ ಯಾರು?
I am the original owner from 1949.
1949.
Yes, my lords, the wife of the original owner, my lords. The wife of the original owner, 2002 nal tirkotare, the husband, the actual owner. And then what happens is she presumes that she continues to be the owner. Defendant number 4 occupies that place, and for vehicle parking, okay, defendant number 4 adaru avaru occupy ಮಾಡ್ಕೊಂಡು they keep paying some rent. Later on she tries to sell that property and she realizes that these kind of documents have come to effect. adu bare EC nal ತೋರ್ಸಲ್ಲ ಸ್ವಾಮಿ ಇಲ್ಲಿ. In this particular matter, the EC does not reflect any of these transactions because they bifurcate the property into 2, and between the same parties the transactions are being conducted. My case is petitioner 1 and 2 are totally different persons, my lord.
Where is the GPA? ನಿಮ್ಗೆ ಕಾರ್ ಪಾರ್ಕಿಂಗ್ ಎಂಜಾಯ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ವಾ? ಪ್ರಾಪರ್ಟಿ ಎಂಜಾಯ್ ಮಾಡಕ್?
ಪ್ರಾಪರ್ಟಿ ಕಾರ್ ಪಾರ್ಕಿಂಗ್ ಅವ್ರ ಮೇಲೆ ನಾವೇ ಕೇಸ್ ಹಾಕಿದ್ದು. ಅವ್ರ ಮೇಲೆ ಖಾಲಿ ಮಾಡಿಸಿ ಅಂತ ಕೋರ್ಟಿಂದ ಆದೇಶ ಆಗಿದೆ. ಮತ್ತೆ ಏನು ರೆಂಟ್ ಪೆಂಡಿಂಗ್ ಇತ್ತು ಅದನ್ನು ಕೊಡ್ಬೇಕು ಅಂತ ನಮ್ ಫೇವರ್ ಆದೇಶ ಆಗಿದೆ.
Your lordships,
ಬಟ್ ಅಲ್ಲಿ ತನಕ ಇವ್ರು ಏನು ಕ್ಲೈಮ್ ಮಾಡಿಲ್ಲ. ಇಲ್ಲಿ ತನಕ ಕ್ಲೈಮ್ ಮಾಡಿ ಈಗ ಬಂದ್ಬಿಟ್ಟು ನಂದು ಪ್ರಾಪರ್ಟಿ ಅಂತ ಕೇಳ್ತಾ ಇದಾರೆ. ಅವ್ರದ್ದು ಏನು ಪಿಟಿಷನರ್ ಹಸ್ಬೆಂಡ್ ಇವರೇ ವೈಫ್ ಅನ್ನೋದಕ್ಕೆ ಯಾವ್ದೇ ರೀತಿ ಒಂದು ದಾಖಲೆ, ಒಂದು ಆಧಾರ್ ಕಾರ್ಡ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ ಹೊರತು ಅದ್ ಬಿಟ್ಟು ಬೇರೆ ಏನು ಕೊಟ್ಟಿಲ್ಲ. ಅವ್ರದೇ ಪ್ರಾಪರ್ಟಿ ಏನಾಗಿದ್ರೆ ಇಷ್ಟು ವರ್ಷ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರು?
ಎಲ್ಲಿ ಇದು ಪ್ರಾಪರ್ಟಿ?
ಕಾರ್ಡ್ ರೋಡ್.
near Minerva circle, my lord.
ಎಸ್, ಪ್ರಾಪರ್ಟಿ ವ್ಯಾಲ್ಯೂ ಜಾಸ್ತಿ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಈ ತರ ಪ್ರಾಬ್ಲಮ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
Your lordships, if I may read out.
I also have to digest.
Yes, ma'am.
ನೀವು ಅವ್ರಿಗೆ ಮಾರಿ ಇವ್ರಿಗೆ ಮಾರಿ ಸೈಕಲ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. Yes. Anything else? Heard reserved. Yes.
Reporting settlement.
Next Friday, yes. List next Friday.
Rating orders 139.
For the petitioner, your lordship. Serial number 139.
Reopen for the purpose.
It's for the reopening and.
Oh, this is 2 years delay. Yes.
Yes, your lordship.
Heard
Lordship.
reserved. Yes. Yes.
Much obliged.
Reserved. I'll pass orders. Yes.
Much obliged, lordship.
Yes.
Final hearing 140.
Next 31st, 2:30 p.m.
Other hearing 141.
Hearing for the petitioners, my lords.
Respondents in this case.
ಇಷ್ಟೊಂದಿದೆ ಮೇಡಮ್.
Hearing on behalf of the petitioners, ma'am.
2:30 ಇನ್ಯಾವುದಿಲ್ಲಲ್ಲ? Yes, still hypermart. Start.
We are engaging a senior counsel, my lords.
Already engaged. The
Well,
madam
there's
had come. Where is she?
There's some inconvenience. So if a short date may be
You have to
accommodated
do
in
it.
the
ಅವ್ರು
matter.
ಮಾಡ್ಬೇಕಾ ಇನ್ನು?
That's one of their leading counsels had finished his argument.
Yes.
Madam wanted to continue.
Yes, she had certain other submissions to make. A short date may be accommodated.
Tuesday.
Tuesdays.
We are ready with that.
142.
Please.
Most grateful.
Appearing for the petitioners.
Yes, Abdullah.
My lords, in this case, my lords, they have sought for the apology letter. We have given that one.
ಅಡಿನಾ?
ಅಪಾಲಜಿ ಲೆಟರ್ ಬಂದಿದೆ ಸ್ವಾಮಿ, ₹1 ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ರೆ
₹1 compensation.
It may be taken up in next week, my lord. Without settling the matter, my lords, they have published the apology letter in social media.
ಸೆಟಲ್ಮೆಂಟ್ ಪಬ್ಲಿಷ್ ಮಾಡ್ಬಿಟ್ರಾ?
Settlement ಆಗ್ದಿರಾನೆ apology letter ಎಲ್ಲ ಕಡೆ publish ಮಾಡಿದ್ರು.
ಆಯ್ತಲ್ಲ ಮತ್ತೆ. ಡೆಫಮೇಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಾಯ್ತು, ಅಪಾಲಜಿ ಕೊಟ್ಟಾಯ್ತು, ಇನ್ನೇನ್ ಬೇಕು? ₹1 ಕಾಂಪನ್ಸೇಷನ್ ಬೇಕಾ?
ಅವ್ರಿಗೆಂತ
ಎಸ್. ಲಿಸ್ಟ್ ಆನ್ 2 weeks ಬಿಟ್ಟು ಹಾಕಿ ಮಾಡಿ. 12th ಅಲ್ಲ, 22nd.
Great.
143.
Appearing for petitioner, my lords. The outgoing counsel is unwell, my lords. Kindly it may be taken up.
ಸರ್ ಕಲ್ಯಾಣ್ ಬಸವರಾಜ್. ಕಲ್ಯಾಣ್ ಬಸವರಾಜ್.
Unwell, my lords. Tejas.
Oh, Tejas ಇದ್ದಾರೆ. So, counsel for the petition submit so and so is unwell. List on 23rd. Interim order ಇದೆಯಾ?
This one.
Yes.
May be extended.
Madam? 11 23rd. Yes. ಯಾವ್ದು?
144.
ಕುಮಾರ್ ಸರ್ ನಿಮ್ದು ಯಾವ್ದು?
Twitter.
ಟ್ವಿಟರ್? ಇಲ್ಲ, ಟ್ವಿಟರ್ 5 ಗಂಟೆಗೆ ಮೀಟಿಂಗ್ ಇದೆ, ಅದಕ್ಕೆ ಐ ಟೋಲ್ಡ್ ಟ್ಯೂಸ್ಡೇ ತಗೊಂತೀನಿ.
Oh, sorry, I did not know that. That's why.
ಸಾರಿ, ನಾನು ನಿಮ್ಮನ್ನು ನೋಡಲಿಲ್ಲ. ಅವ್ರಿಗೆ ಅವರು ಬರಲಿಲ್ಲ. 2:15 ಹೇಳಿದೆ ನಾನು.
Tuesday.
ಟ್ಯೂಸ್ಡೇ. ಏನಿಲ್ಲ ಇದ್ರಲ್ಲಿ.
That's already granted.
ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್. ಕೊಡಿ.
Some submission.
Some submissions. What, Amar sir?
Lots in
ಏನಿದೆ?
this.
ಇಂಟ್ರಿ ಆರ್ಡರ್ 3 ಪೇಜ್ ಇದೆ, ಅದೇ ಫೈನಲ್ ಆರ್ಡರ್.
In fact, what's happened is interim order minutes on the fact specifically. The issue here, Milords, is that the steel, the formwork steel meant for construction, is lying with them. Now, in the interim order, my lord specifically captures there that by 4 emails, we had sought for the return of it, and they had considered, and in fact, it has been disposed of. These are the observations made, my lord. But if the emails are kindly to be seen, not a single email would indicate that there's a response to us to dispose it of. So, my lords, the material as such all through remained with them. Even the last mail, my lords, in fact, my lords would kindly see at page number 70, my lords.
Now come to your complaints.
Please, my lords. It's page 16.
ಸಿವಿಲ್ ಸೂಟ್ ಹಾಕಿದಾರಾ?
There's no civil suit.
Arbitration CMP ಹಾಕಿದ್ದಾರೆ.
ಸಿಎಂ ಆರ್ಬಿಟ್ರೇಷನ್ Arbitration clause
One
alliದೆ.
more thing, my lord. Prior to this complaint, my lord, the in-charge OL had filed a complaint and the police have closed it, saying that this is a civil dispute, you'll have to approach the civil court. That order remains unchallenged, my lord.
ಯಾರು ಹಾಕಿದ್ದದು?
The erstwhile, my lord,
Partner.
resolution professional.
We have relied on,
Professional.
we have relied on this complaint in our objections, my lords. And in fact, my lord, the reason why none of our complaints earlier given were registered into an FIR is because of my lords, the background, the accused here, that's the managing partner of the accused partnership firm holds, my lords. He happens to be, my lords, the grandson of the former Prime Minister of the country and happens to be the nephew of so the ex-chief minister. Now, several attempts made by us, none of it resulted in any FIR register. Now, the issue finally would be, my lords, whether there remains the steel which was used for the purpose of construction, whether it remained with them or whether it was returned. None of the emails, what they claim, my lords, by which they say they have returned to us, none of it would indicate that the steel has been returned to us. What we are seeking, my lords, is there ought to be an investigation as such. Where has the steel gone? Misappropriation, my lords, does not require here entrustment. It has come to them in a neutral manner. In fact, my lords, even though we specifically in our complaint have named the said partner, managing partner of the firm, despite that, my lords, the police have ensured that his name does not get reflected in the FIR. Lords, may kindly see our complaint, page 16.
ಇದು ರಿಕವರಿ ಆಫ್ ಮನಿಗೆ ಎಲ್ಲಿದೆ ಅದೇನಾ?
Recovery of the steel, my lords. Entire steel lies with them. The last document which would, my lords, confirmingly indicate it
ಯಾಕೆ
is
ಸ್ಟೀಲ್ ಕೊಡ್ಲಿಲ್ಲ ವಾಪಸ್?
ವಾಪಸ್ ಕೊಟ್ಟು. Lords, page number 70.
Before the court, my lord, before the resolution proportion, my lord, we put forth a claim. Our claim was 15 crores. It was settled for 11.25 lakhs, to which the amount they have settled. Nowhere in the claim, my lord, they said, the claim, my lord, they said that this steel was really lying with you and we have a claim over it. They accepted the claim which they have discharged. Now to say, my lord, 3 years after that resolution, to say that there is still steel pending with you and we have a claim over it. That too by a director, my lord, who comes in after the resolution process is completed. This is only because, my lord, we filed a complaint against him, he files a complaint. He was unaware of the fact, my lord, that the earlier complaint was filed and it was closed. We were also unaware, my lord, since they filed it in a their statement of objections.
Where is the arbitration clause?
But the agreement, my lord, should find.
Page.
There is the demand for arbitration itself, my lord, on this page. My lords may take the demand notice itself, my lord, at page 104, my lord. 104 is the demand notice, my lord. The arbitration clause is invoked at page 113, my lord. Para 23.
Arbitration is invoked what?
Invoke, my lord.
That remains
Arbitration
pending,
clause.
my lord.
CMP is still pending.
Lords, our specific allegation in the complaint, my lords, is primarily only with respect to the steel. Lords, may kindly turn to page 71. Lords, all the emails that they claim indicate the return. Lords, for a moment, my lords, may kindly turn to page 43, which, my lords, is captured in my lord's order. Page 43. They say this annexure D, commencing, my lords, from page 43 to page 45, would indicate in response to our first email at page 43 that they have returned the steel. None of these emails would indicate that. So their pleading, my lords, is incorrect. Documents do not support that. Then, my lords, at page number 46.
Pursue your CMPs.
But that remains pending. But my-
Recovery of money, I will not permit.
but I am not seeking any recovery of money.
ಮತ್ತೆ?
Let's kindly turn to page number 7.
Still ಏನ್ ಮಾಡ್ತೀರಾ?
ನನಗೆ steel, but it is my steel worth about 3.5 crores, man.
Stolen your steel, no problem.
But he's not stolen. But stealing is one aspect of it.
Now come here, sir. Come to page 113,
Please.
para 22. That is you have caused a notice on them,
Please, my lords.
para 22. Sir.
But this is with respect to the entire dispute as such. Now, for a moment, my lords, where has my steel gone? For a moment, my lords, may kindly turn to page 70.
When did your steel go missing?
But this was in the month of, this was in 2019, December. At that time, my lords, when they terminated the contract. as
Correct. When did you register the crime?
such. So my crime came to be registered in 2023. However, my lords, I initially through the IR.
You are searching for that steel for 4 years.
Because I made my best efforts, my lord, but however, even the IRP made a complaint, my lords, in the year 2020, which document, my lords, was just now produced. Even we have relied on that document in our complaint. For a moment, if my lord should kindly see that, page number 10 of our objections. The IRP files a complaint. This complaint and even this FIR presently is not for, my lords, breach of trust or such offense. It is 421, 422 and 424, which is dishonest or fraudulent removal or concealment of property to prevent distribution among creditors. Then, my lords, dishonest or fraudulent preventing debt being available for creditors. And lastly, dishonest or fraudulent removal or concealment of property. But this 3.5 crores worth steel, my lords, confirmingly it is in their possession as indicated page number 70. my lords. At page 70, we send a letter to them. In this letter, we have specifically indexed, my lords, the details of what is the steel available with them. And to this, my lords, they send a confirmation to the authorized officer that this steel indeed is available. So the issue is with respect to the proceedings before the NCLT or arbitration, that would continue. Because none of this would absolve the crime as such. So the fact that our steel was used, our steel, our steel, my lords, which was lying with them, my lords, there is no dispute. The fact that our steel has not been returned to us is there's no dispute about that. So what is in dispute, my lords, is the other civil litigations as such. Because I filed a complaint, my lords, initially through the IRP, not acted upon. And page 70 for a moment, my lords, to kindly turn page 70. So I specifically say we had hired shuttering material and KNK materials for Northgate project for structure works, and we are at the final stage to stop the work at Northgate project. We need to release the higher material to the vendors. Hereby, we request you to kindly permit us to demobilize all the shuttering material belonging to KNK Construction Private Limited from your site premises. Page 70. Annexure 1 mentions the following materials available at the site, and we shall check the same while loading the materials at the site to demobilize. Then page, my lords, 71 is the detailed list of what material is lying with them, and page 72 may kindly be seen. At page 72, the accused writes a letter to the authorized officer of the accused company itself, page 72. They also admit that these materials at Annexure 1 are still lying with them. But this was never a matter which ought to be considered either before the NCLT or for that matter even in arbitration as such. So the offense has been committed. They ensured that the steel is brought to their premises, and they ensured that none of the security that has been placed when we would be permitted to enter the premises. I'm relying on a few judgments of the
Supreme Court.
My lords, as well as the Honorable Supreme Court, along with the index. Firstly, my lords, with respect to the offense on the, my lords, 403, my submission is there is no there is no necessity, my lords, of an entrustment here. The property which is to the extent the worth about 3.57 crores has gone to their possession in a neutral manner. Was towards in the normal course as such. So there is no, and that has been misappropriated. It has not been returned to us. So that not being in dispute, my humble submission is there's a requirement. In addition to that, my lord, civil litigation as such, I'm also relying on IOC versus NEPC, indicating, my lords, for primarily for 415 and 420, and civil litigation as such merely because there is a remedy under civil law. A crime wouldn't get absolved as such. And lastly, my lord's judgment, Surya Sarin's case, which was in the month of June 2025. So, my last submission is when they succeed, my lords, to an extent of withholding filing of the registration of the FIR. Despite me having mentioned, my lords, the name of the accused, the police ensure that, my lords, the managing partner's name does not get indicated in the FIR as such. This itself would indicate as to the extent of power the concerned individual wields. And
yes, the petitioner is before this court calling in question. You're the sole accused.
Yes, sir.
Petitioner, the accused in crime number 77 of 2023 is at the doors of this court calling in question registration of the crime and conduct of further investigation based upon the said crime. The crime is registered for offences punishable under section 120B, 379, 403, 406 and 420 of the IPC. Heard so and so. Facts adumbrated are as follows. A contract is entered into between the second respondent is the complainant. A contract is entered into between the second respondent and the petitioner for construction of structure and other civil works ancillary to the said construction. The period of completion after the contract was entered into on 9/7/2018 was 12 months, which would come to an end on 31/8/2019. During the subsistence of the said contract, it transpires that the second respondent communicates plethora of letters seeking permission to dispose the scrap steel, which is said to have been later granted by the petitioner. The period of contract then comes to be extended till 31/12/2019. Again, the complainant is said to have requested the petitioners for removal of scaffolding material that was put up in the said premises for the construction. The permission is granted on 2/12/2019.
Just one submission. Nowhere is permission granted. None of the emails.
Government is said to be.
Page 72, permission is granted.
Proceedings then are said to have been initiated. In proceeding idu CPIB.
Not for liquidation.
The proceedings is said to have been initiated by the complainant, the second respondent, seeking liquidation of the petitioner company on account of failure.
Third party had initiated proceedings against the second respondent for seeking
They
their
initiated
liquidation.
against. Adu beda bidi. Idya interim resolution professional.
In that proceedings, my lord, as against the second respondent, an interim resolution professional was appointed in that case.
In those proceedings, yes, certain incidental proceedings have taken place between the second respondent, complainant, other third parties, which may not be necessary for this court to advert to the same in the subject order. The contract between the petitioner and the second respondent complainant is terminated on 25/2/2020. The petitioner then files its claim before the National Company Law Tribunal. The interim resolution professional is appointed and requests to shuttering material, to demobilize the shuttering material in the premises. The said permission is said to have been granted. Long thereafter, the petitioner, new lodge madadra.
First complaint had.
Long thereafter, the petitioner first registers a crime against the second respondent. Adenaithu.
My lord, that complaint, a criminal petition was filed, which they later withdrew, my lord.
Withdrew. Oh, the other one which is connected to this. The petitioner is said to have registered a complaint against the second respondent for offences punishable under section 465 and 471 inter-alia, which was challenged before this court in writ petition, criminal petition so and so, which comes to be withdrawn on adela dates code. Yes, so and so. After the registration of the crime by the petitioner, the second respondent complainant registers the subject crime on 15/6/2023, alleging that the petitioners have not returned the steel that was with them to the hands of the complainant. Complainant. This becomes a crime in crime number 77 of 2023. Registration of the crime is what has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner Abhinay Vaiti would reiterate the grounds urged in the reiterate the contentions advanced as averments in the petition to contend that the petitioner registers the first crime against the petitioner for stealing and stealing of the seals and forging the for letterheads, forging the communications between the two, and therefore the said crime is said complaint becomes a crime in crime number 20 of 2023, challenge to which is withdrawn. The subsequent, after the crime registered by the petitioners as a counterblast, the second respondent registers the crime for demand of steel or an amount of rupees 1,40,193.62. Ashta, ಎಷ್ಟು demand? Steel worth how much?
3.57 crores.
Demand of rupees 3.5 crores.
3.17.
3.17 crores worth of steel. The learned counsel will further submit that the complaint is registered for recovery of money and nothing else. And recovery of money and nothing else would submit that criminal law cannot be set into motion for the purpose of recovery of money.
406 and 420 may not cannot go.
He would further add that section 406 and 420 cannot go hand in hand, is the settled principle of law. The learned counsel for the respondent submits that the issue may at the first blush look like an offense being civil in nature, but it is settled principle of law that a given fact can give rise to both crime and the civil proceedings. He would submit that a perusal at the complaint would nowhere indicate that it is for the purpose of recovery of money. The steel has not been delivered to the complainant, and therefore the complaint is registered. He would admit the fact that the steel was not delivered in the year 2019, and several proceedings had cropped up between for over 4 years, and then in 2023 the crime comes to be registered against the present petitioner, the accused. He would submit that investigation in the least is necessary to be conducted in such a case where there is on the face of it cheating and breach of trust. I have given my source. The aforenarrated facts link in the chain of events are all a matter of record. The entire issue revolves around a contract between the petitioner and the respondent. The contract is for the purpose of construction of a structure and other ancillary constructions to be taken up by the petitioner accused. The contract is entered into between the two. The contract also contemplates arbitration to be a mode of resolution of the dispute. It is therefore the mode of resolution of the dispute. The dispute was with regard to return of steel worth 3.17 crores. Therefore, the complainant causes a legal notice upon the accused. Certain paragraphs of the legal notice that are germane to be considered read as follows. Page 113, para 22-23. This is the notice first caused by the complainant against the petitioners, upon the petitioners. The demand here is of several crores, which also refers to arbitration to be the mode of resolution of the dispute. The dispute does not get settled. The petitioners register a complaint before the jurisdictional police alleging forgery and fabrication of records by the complainant against the by the complainant. This becomes a crime in crime number 20 of 2023. After the registration of the crime, the subject complaint is registered on 15/6/2023. Since the present proceeding has sprung from the complaint, I deem it appropriate to notice the complaint. The complaint reads as follows. A perusal at the complaint would unmistakably indicate that it is registered on two counts. One as a counterblast to what the petitioners register against the complainant, and the other to recover the amount, the steel, which is worth 3.17 crores, which is said to be lying with the accused since 2019. But the complaint comes to be registered in the year 2023, 4 years after the registration of the crime, 4 years after the alleged incident of withholding of the steel by the petitioners, which the learned counsel for the petitioner would seriously dispute that the steel is with them and had to be returned to the complainant. Be that as it may, what unmistakably emerges from the notice and the complaint so registered is that the criminal law is set into motion for the purpose of recovery of steel, in turn recovery of money. Whether this is permissible or not, whether criminal proceedings could be initiated for the purpose of recovery of money is need not detain this court for long or delve deep into the matter. The apex court in the case of Lalit Chaturvedi versus so and so 2024 SSC online SC page 171 court paragraph 4 to 10 has held as follows. The apex court clearly holds that setting the criminal law into motion for the purpose of recovery of money should not be permitted, and such cases should be nipped in the bud in exercise of jurisdiction under 482 of the CRPC. The apex court a little earlier to the judgment in the case of Lalit Chaturvedi, in the case of Deepak Gaba versus Union of India 2023 3 SCC page 423 has held as follows, para 12 to 30. The apex court holds that in matters which are clearly which are seemingly civil in nature, criminal law must not be permitted to be set into motion. A caveat. This would not become applicable to each and every circumstance. A given set of facts can give rise to both instances. One, the civil remedy, and other, the criminal culpability. It would not mean that merely because a civil proceeding is instituted or institutable, it would mean that the criminal law that is being set into motion should be obliterated. It would depend on facts of each case. The facts obtaining in the case at hand would not permit any further investigation even to be permitted to be, would not mean that investigation should be permitted to be continued even on the aforesaid factor of the criminal law being set into motion as a counterblast to what the petitioners had registered and for the purposes of recovery of money. Above all, for the steel that went missing allegedly in the year 2019, the complainant is said to have woken up from slumber and registered the claim on 15/6/2023, 4 years after the steel allegedly gone missing or the money from the steel not reaching the doors of the complainant. Permitting further proceedings in the teeth of the said delay also would run foul of the judgment of the apex court in the case of Chanchalapati Das versus State of West Bengal 2023 SSC online SC page 650, where the apex court holds that delay would undoubtedly vitiate the proceedings. Delay would vitiate the proceedings. Unexplained delay would undoubtedly vitiate the proceedings. In that light, on all the aforesaid score, permitting further investigation even in the case at hand, against the accused would run foul of law, become an abuse of the process of the law, and result in miscarriage of justice. For the aforesaid reasons, allowed quashed.
Please. Please.
ಅವ್ರದ್ದೊಂದು ಜಡ್ಮೆಂಟ್ಗಳು ಹಾಕ್ಬೇಕು. ಅಲ್ಲೊಂದು ಪ್ಯಾರ ಬರೆದ್ರಲ್ಲ, ಇಟ್ ಕ್ಯಾನ್ ಗಿವ್ ರೈಸ್ ಟು ಬೋತ್ ಸಿವಿಲ್ ರೆಮಿಡಿ ಅಂಡ್ ಕ್ರಿಮಿನಲ್ culpability. The judgments relied on by the learned counsel appearing to insofar as the judgments relied on by the learned counsel Amar Korea is concerned, there can be no qualm about the principles so laid down by the apex court or this court in those cases. They are qua the facts obtaining in each of the case. Therefore, in the light of the judgments of the apex court in the case of Deepak Gaba and Lalit Chaturvedi, as also Chanchalapati Das quoted supra, the judgments relied on by the learned counsel for the petitioner respondent would not become applicable to the facts of the case, and therefore they are distinguishable without much ado. Yes.
For petitioner, man.
Petitioner,
Praise for 1 week time.
praise time,
Praise time.
grants time ಆಗೋಯ್ತು.
Enquiry report I have received yesterday one.
Extra copy na?
Yesterday only I have received enquiry report.
Received what, sir?
Enquiry report, man.
ಏನ್ serial number 145?
145.
Oh, departmental enquiry. ಆಯ್ತು, learned counsel for the petitioner, praise time, grants time. ಎಷ್ಟು ದಿನ ಬೇಕು?
1 week.
ಒಂದು ವಾರ. ಲಿಸ್ಟ್ ಆನ್ 14.
46.
Appearing for the respondent.
ಮಹೇಶ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ?
ಹೌದು ಸರ್, ಇದೆ. Interim
ಇದು 498 ಏನಾ?
ಇಲ್ಲ
376 and
420
and
420 my lord.
ಎಷ್ಟು ವರ್ಷ ರಿಲೇಶನ್ಶಿಪ್?
No relationship my lord. It's a monetary transaction. Recovery of the amount ಗೆ ಇವರು ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿ
ಟ್ರಾನ್ಸಾಕ್ಷನ್ 376 and 420 ಯಾಕೆ ಎಷ್ಟು ದಿನ ಇದ್ರೆ ಹೇಳಿ?
Yes my lord, there are too many complaints my lord. Multiple complaints have been filed. ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿದಾಗ ಇವರು 40 ಲಕ್ಷ 55 ಲಕ್ಷ ಒಂದ್ ಕಡೆ ಹೇಳ್ತಾರೆ, ಇನ್ನೊಂದು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ 75 ಲಕ್ಷ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. ಅಂಡ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ದ ದುಡ್ಡಿಗೆ
ಪರಿಚಯ ಇಲ್ವಾ ಕಂಪ್ಲೇಂಟ್?
ಇಲ್ಲ, ಪರಿಚಯ ಇದಾರೆ ಸ್ವಾಮಿ. ಪರಿಚಯ ಇದ್ದು ದುಡ್ಡು ಮಾನಿಟರಿ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಸಾಲ ಕೊಟ್ಟಿದ್ದಾಗ ಅವರು ಆತರ ಹೇಳೋದು, ನಾನು ಹೆಚ್ಚಿಗೆ ದುಡ್ಡು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ, ನಾನು ಫಿಲಂ ಪ್ರೊಡ್ಯೂಸರ್ ಆಗಿದ್ದೀನಿ, ನಾ ಹೆಚ್ಚಿಗೆ ದುಡ್ಡು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ನಾನು ಕಮಿಟ್ ಆಗಿದ್ದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಯು ಆರ್ ಫಿಲ್ಮ್ ಪ್ರೊಡ್ಯೂಸರ್?
2 ಸಣ್ಣ ಫಿಲಂ ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಹಾಗಾಗಿ ಆ ಟೈಮ್ ನಲ್ಲಿ, ಇವಾಗಲ್ಲ, ನಾಟ್ ನೋಟೆಡ್ ಫಿಲಂ ಪ್ರೊಡ್ಯೂಸರ್ ಅಲ್ಲ ಸ್ವಾಮಿ.
Recently he has produced 2 movies my lord. It's a big budget movie.
ಮೂವೀಸ್ ಏನಾಯ್ತು?
Movies release it has been released my lord.
ಫ್ಲಾಪ್
ಮೂವೀಸ್ ಏನೋ ಆಗ್ಲಿಲ್ಲ.
ಮೂವೀಸ್ ಎರಡು ಫ್ಲಾಪ್ ಆಯ್ತು.
ಯಾವುದು? ಎಸ್ my lord.
Well-known director S. Naran has directed the movie. It's a movie called Vide, but it has not been successfully.
5D ಅಂತ ಒಂದು ಮೂವಿ, ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಕಲರ್ ಆಫ್ ಟೊಮ್ಯಾಟೊ ಅಂತ ಒಂದು ಮೂವಿ ಮಾಡಿದ್ದಾರೆ.
ಕಲರ್ ಆಫ್ ಟೊಮ್ಯಾಟೊ?
ಎಸ್ my lord.
ಅದಕ್ಕೆ ಕಲರ್ ಆಫ್ ಕ್ರೈಮ್ ಬಂದಿರೋದು.
No my lord, absolutely there is no
ಕಲರ್ ಎಲ್ಲ ನೀವು ಟೈಟ್ಲ್ ಇಟ್ಕೊಂಡ್ಬಿಟ್ರೆ ಹೆಂಗೆ ಮೂವಿಗೆ?
ಇಲ್ಲ my lord, I'll convince this honorable court with
what tomatoes color you will convince?
No my lord, about the case my lord, about the petitioner's case my lord. Kindly a week's time may be granted.
All right. ಆಮೇಲೆ ತುಂಬಾ ರೈಪ್ ಆಗೋಗ್ಬಿಡುತ್ತೆ ಟೊಮ್ಯಾಟೊ.
No my lord. ಇಲ್ಲ.
Yes. List the matter next list on 14th.
Except 31st. Oh my. Okay my lord. 14th ಆದ್ರೆ
14th August.
ಸರಿ please my lord.
Interim order will continue. Yes.
Please my lord.
The 14th ಹಾಕಿ. It's music.
48.
ಮಲ್ಲೇಶ್ 147 ಮಲ್ಲೇಶ್.
ನೀವು ಏನು ಎಲ್ಲ ಹೋದ್ಮೇಲೆ ಬರ್ತಾ ಇದ್ದೀರಾ? Yes. 14. Yes.
Interim order may be extended, Malesh.
Extends. Yes.
It's music, my lords. There are 3 agreements to be seen. So according to us, my lords, we'll be able to point out there's no violation of any copyright, nor is any case made out for cheating. I still have an existing copyright.
ಯಾವ movie song play ಮಾಡಿದ್ರಿ?
Various, my lords. It comes in packages, various songs.
This is in the Uber, is it?
My lords, it comes in a platform. It's a different platform, my lords, not Uber.
After 1 week.
Well,
sorry, which is it?
ಅಲ್ಲ ಆಫ್ಟರ್ 1 week ಸಾಂಗ್ ಅಲ್ಲ ಅದು
Song, right,
ಟೈಮ್
right.
ಕೇಳಿದ್ರು.
Which platform?
ನೀವು ಯಾವ ಎಲ್ಲಿ ಮ್ಯೂಸಿಕ್ ಪ್ಲೇ ಮಾಡಿದ್ರೆ ಆಫ್ಟರ್ 1 week ಅಂದ್ರೆ ಅವ್ರು ಅಷ್ಟೇ.
Which is name, platform, name of the platform. Well, Spotify, it comes even in Spotify. So my lords, probably I will have to show those transactions.
You had a copyright?
Yes, my lords, according to us, we have it.
Subsisting till when?
My lords, it's subsisting as on the date when the complaint was given also. For 5 years, my lords, totally we had a copyright for about 5 years. So my lords, there are 3 parties involved. It is not just bi-party but tri-party, my lords. They had entered into an agreement with one other party. They had entered into an agreement with us where we had the copyright to play this. And then, my lords, that was for 3 years. Now we entered into a direct transaction with them for 5 years. The addition that I've got is 2 additional years. For the first 3 years, I was fully covered, my lords. I had the copyright. Their case is that no, even those years you didn't have copyright. We will be able to demonstrate from the terms of the contract.
Complainant MRT music. Who is the complainant?
My lords, complaint MRT.
ಅದೇ earlier ಲಹರಿ.
Lahari. So my lords, that hits music. So 2 contracts which we had, my lords. One contract in subsistence for 3 years. The other contract which we had, my lords, with them was for 5 years. So the benefit I'd have got is only for the 4th and 5th year. And this contract runs in such a way, my lords.
Copyright violation.
It's
subsistence ಅಲ್ಲಿ ಇತ್ತಲ್ಲ.
My lords, totally a commercial transaction. I'll be able to point out 2 suits are pending in Bombay, my lords, on this. Because original jurisdiction there. In fact, yes, my lords, we had gone to the district court there, but original jurisdiction, we had to go to the Bombay High Court.
OJ there.
Yes, my lords. Letters patent, so.
Kindly it on Monday, my lords.
Monday?
Please.
Take it on 31st.
Much obliged.
Heard the learned senior counsel Sandesh Chowta appearing for the petitioner at the request of the counsel appearing. Where is respondent? Shyam Sundar.
Shyam appears, my lords.
Where is Shyam Sundar?
Is somehow outside.
Friday evening, Ashwin. Yes. Yes, list the matter on 31st. No, court time agilla.
49.
There's an
Interim order subsisting will continue to the next date. Yes, madam.
49. My lords, the matters are covered by my lord's decision. I have placed citations, FOC matters, my lords. Without arraying company as a party, the director.
We'll close this then.
Please, my lords.
Page.
First decision itself, my lords, at page 1 to 26. My lords, order.
1 to 26.
Of my memo of citations, my lords.
Memo ಕೊಟ್ಟಿದ್ದೀರಾ madam? Memo ಯಾವ್ದು ಕೊಡಿ?
It was heard in detail on a previous instance, my lords. On that I had filed.
HCGP. ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ. These are all company not made party. Anita had a covered. ಯಾವ್ದಿದು? Page 1.
Page 1, my lords. That is my lord's.
Same
order.
matter.
Please, my lords.
The petitioner is before this court seeking the following prayer. The learned counsel would submit that the issue in the list stands answered by the judgment rendered by this court in criminal petition so and so. Forest matter.
Please, my lords.
Company is not made a party here.
Not made a party, my lords.
Adar beda barak ಹೇಳಿ ಅವ್ರಿಗೆ.
Please.
Jagdish ಇಲ್ಲ ಅಲ್ಲ. Yes, list on Thursday. Interim order subsisting will continue till the next date of hearing.
Grateful, my lords. 150.
Madam, ಎಷ್ಟಿದೆ? 161.
Mellots 150.1 and 150.2 mellots. Praise time mellots. Senior is.
Praise time, grants time, no time.
Yes. There's an interim order.
There's an interim order. All other further hearing matters will repeat on 23rd. Interim orders will continue.
One submission. Lordship has granted interim order in favor of the wife.
ಯಾವ್ದ್ರಲ್ಲಿ? BC, please wait, madam. Yes.
151. Right. 151. And the husband is about to come, but on 2 occasions the matter was not.
Husband?
Husband is in Dubai, madam. Wife has come and appeared before the police for investigation. But Lordship has heard.
ಆಯ್ತು ಅದೊಂದು ಮಾತ್ರ 7th ಹಾಕಿ ಮೇಡಮ್.
Tuesday kindly, madam, because he booked tickets twice and he was not able to come to.
No, ಇರ್ಲಿ ಅದು 7th ಹಾಕಿ.
Serial number
7th ಹಾಕಿ.
serial number 153, my lords. Your Lordship were already pleased to quash the proceedings. And memo for being spoken to also was filed subsequently, my lords.
We'll see. Allah barli.
My lords, serial number 160.
154. Sirajuddin, wherein?
My lords, serial number 160 with the connected matters. Request you to please take out, delete the name of Prasanna Kumar and add Onni Krishnan.
Yaudral.
160, I am there, my lord. He's mentioning 160, then I am there. In 160.
160. Special court matter. Oh, this 160. Prasanna Kumar should be deleted.
That's what I was got instructed. So, Onni Krishnan name should be added.
Our tenure has come to an end, my lords. Therefore, our name may be deleted.
Registry to delete the name of P. Prasanna Kumar as appearing for the Enforcement Directorate and print the name of M. Onni Krishnan. Yes.
My lord, serial number 157. Regarding the
23rd July. 23rd.
No, we'll take it on.
My lords are keeping it on 23rd.
Yes, sir, 23rd.
August.
It's a working Saturday. Yes.
Very well.
Number 157.
My lord,
Your senior advocate Jana Kothari is appearing online. This is regarding the rare disease policy, Your Honor.
Rare disease matter. My lord.
1 minute, I'll take that. Wait. Yes.
Please.
Rest of the matters on 23rd. ಅದೇನಾಯ್ತು ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ಲಿಲ್ವಾ?
3 crores 34 lakhs total award amount. They have given a proposal to pay us to 1 crore. The same thing, our client told that my clients are ready to give 1 crore to them. Now I given a proposal. Out of 3 crore 34 lakhs, 2 crores to the landlord. 1 crore 34 lakh with interest to them. I have given a proposal.
ಮಾತಾಡಿ ತೊಂದ್ರೆ ಇಲ್ಲ. ಅವತ್ತೇ ಇರಲಿ 23rd. 23rd, yes. ಆಯ್ತು ತೊಂದ್ರೆ ಇಲ್ಲ ಇರಲಿ.
Report ಕೊಟ್ರೆ at least we can respond to that.
ಅಯ್ಯೋ ಅಷ್ಟೇನಾ? ವೇಟ್ ಮೇಡಮ್, ಅಪ್ಲೋಡ್ ಆಗಿರುತ್ತೆ.
That review.
Yesterday's matter ಅಲ್ಲ?
Today.
ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಾ?
Oh, morning your lordship passed it over and said, but in any event.
Oh, that issues. Tuesday. Monday I'm not sitting. Tuesday.
I have only one request, Lord. Matters coming up on Monday for evidence. The judge is insisting, Lord, that I must lead evidence or I will dismiss them.
Review ಹಾಕಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ ಹೇಳಿದೀವಿ.
I appear to respond in that matter. There is some urgency only because the matter set down for evidence on Monday.
So let not the court consider it on Monday. I'll take it on Tuesday.
Tuesday may be had. Proper the list because it's anyway part heard right now.
Review, it will come in admission itself.
Because there is a direction by the coordinate bench of this court to dispose of the matter.
I'm aware of that case.
I'm just requesting that it be taken up.
Tuesday we'll take it.
I hope my lieutenant won't insist dismissal of the suit on Monday, my lord. Review may become infructuous.
No, what will become infructuous?
Review will become infructuous. Suit is dismissed.
There is an understanding.
With whom?
No, I mean, before this court, it has been heard today in past.
Before this court, there's an understanding. But what about that court?
I will not.
I don't think that court will understand the understanding here. So the concerned court shall defer its proceeding till Wednesday. We'll take it on Tuesday.
Serial number 40.
Serial number ಯಾವ್ದು ಕೇಳ್ಕೊಳ್ಳಿ.
Serial number 46 passed over matter withdrawal of amount. 2018 decree.
It will come, sir.
Lord, costless number.
At least.
That rare diseases matter.
Yes, my lords. 157, number 157, my lords, I have.
What happened? Did you appear before the?
We appeared. In fact, my lords, we appeared.
Yes, Shantibhushan, what has happened?
An affidavit. They don't, in fact, as per the rare disease policy, they don't even entertain me because our disease falls under group 3, which says that where the cost.
Center of Excellence, ಯಾರು appear ಆಗ್ತಾರೆ? ಇದು.
They have outright.
1 minute, madam. What is the serial number?
157, madam.
List 157 in preliminary hearing on Wednesday.
Second list. Extension of parole.
Extension of parole on Tuesday.
Second list, my lord. 278. My lord, in this matter, we had asked for sought for a forensic audit on a builder. It has been tagged with other matters, my lord. Second list, my lord.
Second list will repeat.
My lord, it has to be dealing